Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Get it taken care of. Okay, so this is case number 2402970. This is Melrose 20 versus Charisse, Charissee Lewis.
Good afternoon, Your Honor. Tamara Fraser appearing on behalf of plaintiff Melrose 20.
And good afternoon, Ms. Fraser. Ms. Lewis, are you there?
Yes, ma'am.
Tell us your name.
Charisse Lewis.
Okay, and I'm sorry you all were stuck in the breakout room.
I didn't see anywhere for us to signal to the court to get back in. And when I called, then it suddenly said the breakout session would end in 40 seconds or something. So
that's because someone told me, and I actually closed the door. I closed the door.
Thank you.
Usually there's a button for you to leave the breakout room or return to the meeting, but you couldn't find that button.
I didn't see anything on our screen, so I'm glad we reunited with you.
Yeah, me too, because we were wondering, but she said, well, they're still in there. We're used to people coming out, so we didn't check.
Okay.
All right, but no problem.
Well,
so we're back today. So this is a non-payment case. Did you all have ample opportunity to discuss?
Indeed we did. Ms. Lewis and I discussed entering a consent judgment today. And I have the dollar amounts available here. I actually have a version that has been docu-signed by Ms. Lewis as well. As signed by me that I could submit to the court. I'm just not sure how you accept those.
Okay, well, what we do is you would have to scan those, in to the My File system, since we don't have a paper file on this particular file. But let me see what I can do. I can actually
when we're done with the hearing today, I could certainly have my assistant submit it through My File to the court.
Yeah, that's exactly what you would do.
Okay.
So let me put up the file on your matter online here. Okay, here it is. And so, Ms. Lewis, we had adjourned this previously for you to try to work something out, and apparently that you are willing to enter into a consent judgment with your landlord to resolve this case. Is that correct?
Yes, Judge.
Okay. And do you remember watching the advice of rights video when we were here previously that told you all of the rights that you normally did have in the kind of non-payment of rent cases?
I did not see that.
Not a problem. We can actually read you those rights just so you understand that you're going to be waiving these rights and entering into a consent judgment today. So let me get it for you. So normally in a non-payment of rent case, you would have the right to have an attorney. And if you couldn't afford an attorney, the court would give you information about legal assistance available in this area. And that would be Lakeshore Legal Aid, which would be the lawyers that you could possibly speak with to determine if they could represent you or at least give you some advice related to your issue. You would also have a right to have your case heard in the court where the property is located. You're probably in that correct court at this point. But if you weren't, you could have the case transferred to the proper court by filling out a specific form for that. You have a right to have a jury trial in this type of case, and you would have to demand the right to a jury trial by filling out a form called MC-22, which we could get to you. And if you demand a jury, you'd have to do so within 5 days of the court advising you of this right and pay a $50 fee unless the fee is waived. You would also have the right to ask to adjourn the case to seek rental assistance from either Michigan Department of Health and Human Services, a local coordinated entry agency, or a housing assessment and resource agency. We do have Community Housing Network in Troy, Michigan, which may be of some assistance. Or there's a program called Federal Help for Homeless Veterans. You should have received all of that information with the original summons and complaint. And obviously, you do not need a judgment in order to apply for that assistance. You would just need a copy of your summons and complaint to show that you have a case pending. And at that first trial date, the court would allow you to adjourn the case 7 to 14 days to apply for that assistance and seek counsel. And if you're looking for assistance, there's a form that you would have to fill out. It's called DC 539. You fill out that form and file it, indicating that you are going to apply for assistance. And then within 5 days of the date that you fill out the form, you have to come back to the court with documentation showing that you actually did apply for assistance. So then on the adjourn date, we would ask you to fill out that form again to show us the status of your assistance. Is it still pending? And if it is, you would have to have filed something to show that it's still pending, and we can adjourn the matters up to 28 days. So you also have the right to work on a conditional dismissal of the case with your landlord. That's where both parties agree to certain terms. The case gets conditionally dismissed as long as the defendant adheres to the terms of payment. And if not, then the case is reinstated, a judgment is entered immediately, and a writ to evict you is entered immediately. But the benefit of the conditional dismissal is there's no judgment unless you fail to comply with the terms that you agreed to. And you would also have the right to try to resolve your case outside of court through what we call local community dispute resolution or mediation. And of course, you could ask the court about that or go to courts.mi.gov/CDRP and get more information as to how to sign up to take your case temporarily out of the system to see if it could be resolved by a third-party mediator who would basically talk to both sides, try to work out some resolution that you could both live with. So those are the rights that you normally have in a landlord-tenant non-payment of rent case that you would be waiving by entering into a consent judgment. So do you understand that, Ms. Lewis?
I do understand.
And would you like to waive those rights to enter into the agreement that you've worked out with your landlord?
Yes.
All right. And what are the terms of the agreement now, Ms. Fraser?
Yes, Your Honor, we would be entering the consent judgment. You want the dollar figures for each line?
Yes, I'd
Just
like
the total.
to have, break out the rent, the court
Okay.
costs, and then the total.
The rent is $1,549.63. The other money due is $8,832.74. The costs are $164 for a grand total of $10,546.37.
What's the other money due consist of?
It consists of taxes, CAM charges, late fees, attorney's fees.
Well, you don't get attorney fees. You only get a $75 statutory attorney fee.
The 75 is included in the costs, but the terms of the rent, this is a commercial rental agreement,
It's commercial.
includes attorney's fees.
Okay, it looks residential because it's her name.
Yes, yes, it is. But it's an individual. It was leased in her individual capacity.
All right. Okay, so it's a business lease then, Ms. Lewis?
Yes, ma'am.
Okay, all right. So you're agreeing that $10,546.37 is due right now, including the rent, the cost, and the other money as council just broke down for us on the record, correct?
Correct.
And this is a possession judgment only, Ms. Lewis? Ms. Fraser?
Yes, it's possession only, Your Honor. She understands that if she wants to retain the property, that she's going to have to pay the $10,546.37. I can represent on the record, Ms. Lewis has indicated that she has already vacated the property and does not intend to return. However, since we already had the hearing scheduled and I just learned of her leaving the premises after the hearing started or the time started today, I felt we should go ahead and get the judgment entered. Should we need to apply for a formal order of eviction, obviously we will do that on May 19th, but I think we will be able to work out a voluntary surrender document, which will make that unnecessary.
Okay. Well,
So-
you might consider, if you find out she has already left and everything's done, maybe setting aside a judgment so she doesn't have an individual judgment on her record. A lot of landlords do that if they can't dismiss on the day of the hearing. Because
Okay,
they can't complete possession. So that way it's not an individual record. And I'll just make a note of that. The
Okay.
plaintiff will set
Yeah,
aside and dismiss if you don't need to get a writ.
the landlord request said it would take a day or so for them to verify
So,
everything.
Your Honor,
Yes, ma'am.
since I'm out of the place, the last time we met, it was 6,629. I don't know why they're entering May, because I did get out before May. I did voluntarily to leave before May. 2 weeks.
Well, you just said you were agreeing to that amount, so now you're not. So, okay, she's not agreeing to that amount because she said she had moved before May.
Well, I actually, Ms. Lewis and I discussed this extensively in the breakout session, that since we were at court last time, additional expenses have been accrued because May rent and the payments for the month came due. So in order for her to take or retain possession of the property, she would need to pay not only for the amounts that were due before May 1st, but the amounts that are due after May 1st, which would total.
She doesn't want possession, does she? I thought you said she moved already.
She did, Your Honor, but for purposes of today and entering a possession judgment, that would be the amount that she would need to repay to retain the property. It would include May's rent as well.
I do not want to retain the property.
Okay. So here's the problem with that. If she's gone, she's gone. So why don't we do this? Rather than even enter the judgment, why don't we put this off for 2 days? Your client can confirm, and if she's gone, you can just dismiss. And then therefore, no one has to worry about judgments. And if they have other damages that they want to see, they can file another case.
Yes, but legally.
Okay, because I'm gonna have to set it for a hearing because she's saying that she's disagreeing. I can't do it as a consent.
I understand.
She's saying she's not there. So I would have to have a full hearing as to whether she's there when she moved in order to enter the correct amount. And if she moved before May, I wouldn't add May. You want to add May because you're saying if she were there to remain in possession, but she's saying I'm not there. So
Well-
since that's a dispute, I have to hold a hearing to decide, did she move? Did she leave? How much rent does she owe up until the time she moved?
If I may, Your Honor, the lease that was filed, the rent goes through 2027.
Solomonic wisdom.
Okay.
Like
So,
I care.
Your Honor, that's under the old Melrose.
Okay, listen, I'm telling you, we're gonna set this for trial, because I don't have these documents in front of me. You're saying old lease, she's saying new lease. You're saying you move, she's saying you owe for May, and you don't owe for May if you're not there. But then again, she's saying, well, the lease was longer than this, so what do you want, damages up until when? I'm not really sure, but I can't figure it out today. I'll have to take some testimony.
Okay. Well, if
She's
we
no
can't,
longer- I thought it was a consent judgment,
I
but
did
it's
too.
not.
I did too, Your Honor.
Your Honor, can I say this? The reason why I agreed to consent is because I didn't want it to be like I was being evicted when I was told last month when it came to court that I need to just go ahead and leave out. I said I've never been through an eviction, so I didn't want it on my record. So I went ahead and moved out.
Well, the consent judgment would be an eviction on your record, basically.
Oh,
You have a
well,
judgment.
I don't want an eviction.
Most landlords, if they just want possession, they confirm that they have possession and they just dismiss the case. So I'm not sure why we're ending a judgment if she left.
Well, we need time to confirm.
That's what I said. I
But
can give you a few
I
days.
talked to the owner this morning, and I talked to him while we were waiting in the breakout.
But she doesn't.
He said he
she doesn't
already
know.
looked. Judge, he said he already saw it. He saw there was no damages, and that it was clean. And I do have pictures that saying it
Okay,
was clean.
maybe you can call him, Miss Fraser, if that's the case, and she says she talked to him already. Maybe you can just give him a phone call. Otherwise, I can give you a date.
I had a representative. I had a representative available on the Zoom earlier.
But she was very rude when and she was, the owner told me, I called him. He told me he would call me back in 30 minutes. He didn't. So the lady who she had called, but she was very rude. I got him right now. And I was like, well, he said he would talk to me personally. And so she said, I got him. So he called me and he said that, I told him that we had court today. He said, I'll call you back in 30 minutes. And so he didn't do that. So the other lady, the rude lady, she got him on the phone. So he did end up calling me and he said, well, we'll talk about it in future about it. We will talk about it in the future because he was in travels. That's what he said.
Okay.
And so the reason why I had consented because I talked to attorney Tamara and she said they needed to take possession. And she said she knew, because I told her I didn't want an eviction on my record because I've never had an eviction on my record.
Ooh, can we stop? Hold on, time out. I'm going to adjourn this case to give Ms. Fraser some time. The next civil docket that we have is next week, May 16th at 10 a.m. If she confirms, then she can just dismiss the case. As a matter of fact, she can tell you she's dismissing the case. She can sign a stip to dismiss the case. Nobody has to come back. But if you do need to come back, we'll be here
What's the case number, Judge?
on May 16th at 10 a.m. Now, we won't be able to get a notice out, I don't think, in enough time for that date. We can try.
Can I have the case
Yeah,
number?
case number 2402970 LT, Melrose 20 versus Shari, CHARISSEE Lewis.
Okay.
Yeah.
Thank you.
Okay, so that should take care of it easily.
Because Judge, I know Ms. Fraser heard him say, did you hear him say when he said that the property was in good condition? Did you hear him?
I did not hear him say that, no.
Okay.
But
Let her just verify it. Let her
I'm sorry?
verify it. I'm talking to Ms. Lewis to let you verify it, Ms. Fraser, because she has her job to do on behalf of her client too. And she has not had a chance to discuss that with him. So, we'll just come back next week. And if we need to put something different on the record, we will. But if what you say is true, the case will just get dismissed because they already have possession. And you've already turned in the keys. Okay? So we'll see everybody back here on May 16th at 10.
All right. Thank you, Your Honor.